Hello, welcome to this webinar on the basic principles of adjudication. My name is Edmund Crawley. I'll be presenting this with Youcef Bussabain. We're both junior barristers at Keating Chambers. And this is going to be the first webinar in a series of webinars by Keating on specific aspects of adjudication and certain developments in the case law too. This first webinar will be fairly high-level introduction to adjudication. We'll be talking about what it is, why it's used, and how it is conducted. So without further ado, let's move on to the broad question of what is adjudication. Adjudication developed in the construction context out of a realization that what disputing parties often needed was not so much the right answer, achieved after much time and expense, but just an answer and quickly. An adjudication achieves this purpose by providing a rapid and temporarily binding determination of disputes by an expert tribunal. So in some ways, it's a bit like arbitration or litigation in that it results in an enforceable decision. But it's then different from arbitration or indeed litigation in two key respects. The first of these is that it's an expedited procedure. So adjudication is strictly time limited. Unless the parties agree otherwise, the period between when the dispute starts, when it's first referred to adjudication, and when the adjudicator reaches their decision is typically no more than 28 days. So it's a very fast procedure. It's also almost always determined on the papers alone, so without a hearing, except in some rare circumstances where perhaps cross-examination or briefing is needed. It's nearly always just on papers. As well as this, it's also different from arbitration and litigation, in fact, that it's only temporarily binding. The adjudicated decision, once it's been published, is immediately enforceable and can be upheld in the court. But this is only the case until the matter is then finally determined by legal proceedings, arbitration, or indeed just agreement between the parties. So this is really just a reflection of its expedited nature. It's understood that given the time constraints around adjudication, the result is often a less than perfect resolution. And so the parties are always permitted to then later reach full determination, relitigate the matter, or even just a part of the dispute can be relitigated. Having said that, it is worth noting that in the vast majority of cases, adjudication decisions are not litigated. So even though in theory they are only temporarily binding, adjudication does, on the whole, lead to a final resolution of the dispute. So as a result of these unique aspects, adjudication is fast and relatively cost-effective in comparison to litigation or arbitration. It's very much defined by an ethos of the much quoted phrase, pay now and argue later. It allows parties to essentially just reach a practical solution to their dispute and avoid unnecessary disruption in the process. So in a nutshell, that is what adjudication is and indeed why it exists. So moving on then to the statutory regime which underpins adjudication. By Section 108 of the Housing Grants Construction and Regeneration Act 1996, which, just to save time, I will refer to as the Construction Act, the main part of which is quoted there in the slide. Parties to a construction contract have a right, statutory right to refer a dispute arising under the contract to adjudication. As well as providing this basic right, Section 108 also provides certain procedural requirements which the parties must comply with. There are a number of these, but they include, for example, that the parties may refer a dispute to adjudication at any time. And it even includes, for example, if litigation or arbitration are already on foot. Section 108 also provides that the adjudicator must reach a decision within 28 days, that is, unless the parties agree otherwise. Section 108 also says that the adjudicator must be impartial. So Section 108 provides these sort of high-level requirements that define adjudication in all circumstances. Unless the parties then create their own bespoke terms, the procedure which governs the adjudication process will be, by default, that provided in Part 1 of the Scheme for Construction Contracts 1998, which I'll just refer to as the scheme. As mentioned, the parties can, of course, make their own adjudication procedural terms, but in doing so, it is essential that those terms are compliant with those overarching requirements in Section 108 of the Construction Act. If a single one of those bespoke procedures does not comply with the requirements of Section 108, then the procedures from Part 1 of the scheme will be incorporated wholesale, as it was memorably put by Edward Stuart J. in the Youcef case, which is referenced at the bottom of the slide. If there is any non-compliance, the adjudication provisions in Part 1 of the scheme are brought in lock, stock, and barrel. So it's really essential that if, including your own bespoke terms, that you check that they comply with the Construction Act. Otherwise, the scheme is going to be implied into the contract in its entirety. So that, in summary, is the statutory basis to adjudication. The next question, once you've understood this, is, of course, how does adjudication begin? Well, the first matter to consider, which is often overlooked because it's so basic, is, well, is there a dispute? It goes without saying that if you have a right to refer a dispute to adjudication, there's got to be a valid dispute in the first place. This is often referred to as a question of whether a dispute has crystallized by the time of the referral. And a good starting point for trying to determine whether or not a dispute has crystallized is the High Court's judgment in Amex Civil Engineering, which is referenced there. There is also a Court of Appeal judgment in that case, which extends some of the principles found in the High Court judgment, but the High Court judgment really has the bulk of the relevant principles, so it's worth reading in its entirety. And in this judgment, the court considered and set out some of the principles for what constitutes a valid dispute. And key amongst those are some of the following. The first is that mere notification of the fact of a claim or a right does not, in and of itself, result in a dispute. A dispute requires that that claim or right is asserted and that the other party then goes on to not admit that claim or right. So there's got to be a reciprocal element. But then what constitutes non-admission is relatively broad and will almost always depend upon the context and facts of the particular case. It might, of course, simply just be an outright rejection, where one party says, we believe this is the case, and the other party comes back and says, well, we disagree. It's very simple. Obviously, then there's a dispute. But it can also be implied through conduct, and indeed, it may even be inferred from silence. Though the appropriate length of silence, which constitutes a rejection of a claim, will depend upon, again, the context and the facts. But silence can very much lead to a dispute. Thirdly, another one of the key principles is the fact that if the initial claim is sufficiently nebulous or ill-defined, then it might in fact be impossible to generate a valid dispute out of it, even if the other party's immediate response is to reject the claim. So it's really important when in those initial communications to make very clear what your claim is, because it actually might then later undermine the adjudication process. So the first matter to consider is there in fact a valid dispute? Second thing to consider, again, so basic that it's often overlooked, is, well, is the dispute in the singular? If you look at the wording of Section 108 of the Construction Act, it allows parties to refer a dispute. It does not allow for parties to refer disputes, plural. And so it's essential to make sure that what is being referred is a single matter, a single dispute. Now, having said this, the court's approach is generally fairly relaxed. They don't take an overly legalistic approach to this. Though there are certainly examples of where parties have tried to refer too much, and the courts have then later rejected this. But it's also worth bearing in mind that a single dispute may encompass multiple different issues. So it's not like it's a very strict process in that regard. One useful way of determining whether two separate matters are a single dispute or separate is to consider whether they can be determined without the other. If one cannot be determined without the other, it's very likely they fall under one dispute, though this is by no means a hard and fast rule. And for the full principles on this particular issue, I'd recommend a reading of Witney Town Council, which is referenced at the bottom of the slide. So if it's been established that there is a dispute, that it's in the singular, then a party may initiate adjudication. And the way they begin this is by serving a notice of adjudication. Now, the precise method of doing this will depend upon the procedure adopted by the parties. But under the scheme in paragraph 1, it is achieved by serving a written notice of adjudication on every other party in the contract. And this notice will set out very briefly a description of the dispute, the details of how and when and where it has arisen, the nature of the remedy which is sought, and the names and address of the party. So it's a fairly simple document, just laying out the nature of the claim. It's just putting parties on notice of the fact that an adjudication is about to begin. Once this has been achieved, the next step is to choose the adjudicator. This will again be determined by the procedure which the parties have adopted. If the scheme is being relied upon, then the procedure is set out in paragraphs 2 to 6. There, the adjudicator will be adopted, and then the procedure of adjudication will begin proper. And for that, I will be handing over to Youcef, who's going to take you through the actual process of running an adjudication. So over to you, Youcef.
Thanks very much, Edmund. So I'll be talking about the referral, the response, and further submissions, and finally things to consider when an adjudication concludes. Edmund obviously has touched to some extent on these topics, but I'll be going into slightly more detail. The referral notice follows on from the notices of adjudication and is what the claiming party puts in, and it's the equivalent of the statement of case in arbitration or the particulars of claim in litigation. However, its purpose and nature differs enormously in that, unlike in arbitration or litigation, as Edmund mentioned, there might not be an oral hearing, and usually there isn't. And therefore, it's really important that the referral notice serves almost sort of every possible function in one single all-encompassing document. So, for instance, it should set out the factual and legal basis of the referring party's case. It should refer to the relevant contractual provisions that the party relies on, explaining the basis on which the claim is brought. It should be persuasive and argumentative, cross-refer to all of the relevant documents on which you rely, be supported by evidence, attach all of the relevant legal authorities, and explain how they support the referring party's case. And again, the sort of unique feature of adjudication is its truncated timetable, and that inevitably puts some pressure on the referring party, and particularly the responding parties I'll get onto. The norm being that per section 108 of the Construction Act, that disputes are referred within 7 days of the notice of adjudication. And now really that's quite a truncated timeline. However, parties may agree to defer service if they wish, and I think in practice that does commonly happen, particularly where disputes are relatively large. But note again the importance of at least putting an in principle deferred agreement if necessary, because a failure to serve in the required time could give the responding party a ground upon which to object to any decision that an adjudicator ends up reaching subsequently. Moving to the response and further potential rounds of submissions. Just as with the referral notice, the response needs to be an all-encompassing document. One big challenge for responding parties, however, is that unlike the referring party, it's not in their gift when the adjudication starts. It therefore becomes a pretty good idea, being prudent, for the responding party to start preparing its response and supporting evidence as soon as it looks likely that a dispute's on foot. And often there are such indications in advance because, as Edmund touched upon, one of the necessary preconditions of bringing an adjudication is a crystallization of a dispute. So quite often parties will put in a clear letter, which indicates that a dispute's on foot and an adjudication might well be on the way, which can give you the kind of advance forewarning as the responding party to know that, oh, okay, we need to get ready and start preparing for this, because we may only have 7 days to respond to what could be quite a chunky referral document. Importantly, the responding party can raise any points in its defence that would amount in law or fact to a defence to the claim, regardless of whether those points have been raised in previous correspondence or discussions prior to the referral to adjudication. So in that sense, that's quite different to the position of the referring party. And if the adjudicator declines or fails to consider a defence that has been properly raised, that is likely to amount to a material breach of the rules of natural justice, which in turn could render the adjudicator's decision unenforceable. Now, in terms of further submissions, there's no actual provision in the scheme or any of the adjudication procedures for the referring party to issue a reply to the response or for the responding party to issue a rejoinder. However, in practice, and given the adjudicator's free rein over the conduct of adjudication and the requirements of natural justice, in practice, the adjudicator can and usually does choose to grant the referring party permission to issue a reply, and then subsequently permission to the responding party to issue further submissions and rejoin to the reply. And that process can continue on, although at some point the adjudicator will step in and limit the number of submissions, because again, one of the key points which Edmund touched upon is that the timeline for the adjudicator to reach a decision is relatively limited. So were he or she to continue to allow submissions to be put in, it truncates the time left for them to actually reach the decision. What next? What happens after an adjudication concludes? As I just touched upon, the decision will typically be within 28 days of the dispute being referred, which is one of the reasons why adjudicators might not be willing to give lots and lots of rounds of submissions. And notably, the Technology and Construction Court's approach is generally to uphold adjudicators' decisions robustly, unless the adjudicator plainly had no jurisdiction or there was a material breach of the rules of natural justice. So importantly, the TCC won't interfere with an adjudicator's decision if the adjudicator has made an error in procedure, fact, or law. If a responding party or referring party is unhappy with an adjudicator's decision in that respect, as Edmund touched upon, the policy of the court is pay now, argue later, meaning pay the decision sum and then go on and challenge that in litigation in due course. So in terms of procedure, if a party's got a decision in their favour that they want to enforce, the best place to look to understand the appropriate process by which to bring a claim for enforcement is Section 9 of the TCC guide. And the typical way of issuing a claim is under CPR Part 7, together with an application for summary judgment under CPR Part 24. And the process really is quite quick. A TCC judge will usually hear the summary judgment application within 6 to 8 weeks of the directions order being made. Now, having said that, it's not always the case that adjudication decisions will be enforced. So when is it the right time to resist if you're unhappy with a decision? as mentioned previously, there are limited circumstances where it might be appropriate. The two notable broad categories being where an adjudicator has acted without or in excess of jurisdiction, or in material breach of the requirements of natural justice. Now, I believe there will be future webinars on those topics, so I won't go into them in any detail. But an important point to note at this point is that parties ought to remember that the entitlement to challenge jurisdiction can easily be waived, and therefore that those that's seeking to challenge an adjudicated decision on jurisdictional grounds should ensure that they reserve their right to do so as soon as they become aware of the circumstances giving rise to the challenge. And that can be at any point of the adjudication process, be it as soon as the notice of adjudication is served, the referral notice, the response, any of those steps along the way. If a jurisdictional ground arises, the party who is seeking to rely on it ought to reserve their position at that stage. Now, that was quite the whistle-stop tour of the overall adjudication process. And there will be further webinars to come that address topics of interest in adjudication. So please do look out for those. And thank you very much for listening.